Now, this move has been described as a blow to Shell South Africa as the Grahamstown High Court in Makanda granted that interdict halting its seismic survey along the Wild Coast. Shell has expressed disappointment, as you heard there in that story. Let's talk further now on this with Wilmien Wicomb from the Legal Resources Centre. Good evening to you and thank you so much for your time. What's your reaction to the ruling?
Well, of course, we are delighted, and so are our clients. And I think it's a really, really significant victory, not only for these fishing communities. I mean, I think it's significant that Shell was stopped because the communities were able to show that Shell did not act lawfully in starting the survey. And what's really significant is, I think, Shell told the court repeatedly that the prejudice that they would suffer if this is stopped would be immense to them financially and immense to the country potentially. But the court said, well, that cannot outweigh the constitutional rights of these fishing communities that Shell chose to ignore and now has to face the consequences.
And I wonder, because this is the second application that, was put forward in this particular court. The first one was unsuccessful on the side of the activists. And now the activists have found themselves really breathing somewhat of a sigh of relief. Should Shell decide to appeal this decision, I wonder these two judgments and the difference in them, how much of an impact could that have on the case for the activists or even Shell going forward?
So the two cases were very, very different, and at least two accounts. One, I think, quite significantly, the second case, the applicants are small-scale customary fishing communities who have this very significant connection to the ocean. So the first application was brought by commercial and recreational fishers who also complained of not being properly consulted, but obviously, had a completely different case before the court and were not completely ignored like our clients who actually have constitutional rights and livelihoods depending on this. So that, I think, was a very significant difference that the court recognized. And secondly, in this case, the clients were able to put up evidence of 10 experts showing that in all likelihood significant harm will follow from these seismic surveys. And that was a difficulty in the first case and was the main reason, I think, why the court was not willing to stop Shell in that case.
I wonder, I remember I was trying to speak to one of the activists, but unfortunately the line let us down just in recent days. And one of the things that I really would like to know from the community is what for them would constitute proper consultation, because this consultation issue is, as you say, all of them are complaining about it. The commercial farmers, the small-scale farmers, what will constitute proper consultation for them?
So that's a very, very good and difficult question, which in this case was very easy because Shell did nothing. They did not consult these communities at all, and that was on the papers before the court. So what consultation constitutes is really a case-by-case question, and it depends on how much will the impact be on the community. So in this case, it's their livelihood, it's their cultural and spiritual connection, it's their customary rights. So significant consultation will be required. I would say enough for Shell to understand what they will be impacting and for there to be agreement upon the mitigation efforts. Our clients are not saying we have a spiritual connection to the ocean and therefore no one can ever come near it. They are saying you cannot come here by ignoring us and not offering any kind of balancing exercise between the rights of Shell and the state and our rights as communities. And that's the kind of outcome that you need from consultation.
And it sounds like your clients continue to feel a sense, if I may use this word, bullied, by these Shell as well as government. I wonder then if they think they could ever find each other with Shell if they were to ever come to the table, given how far things have gone.
Look, it's difficult to say with this very particular case, but I do think so. I mean, for example, in Namibia, we put up evidence of one of the experts who in Namibia has worked very much in a consultation between Shell and some fishers there. And they have he told the court, they've come up with solutions that worked for all parties. So I don't think one should say it's impossible. But as long as Shell ignores these communities, then yes, certainly it's impossible for us to get anywhere. And that's why the court had to stop it.
And I wonder then what then would be your advice to your clients tonight, especially should Shell decide that, it's going to appeal and things, actually the matter reaches even the highest court in the land, that's the Constitutional Court, and they find themselves on the back foot here and they possibly lose the case and Shell goes ahead. I wonder how then would they be able to be in a situation to forge ahead and balance their livelihoods as well as what Shell wants to do?
Well, it will be very, very difficult for them to do that if Shell has a blanket refusal to engage with these communities. I can't see that happening. I honestly believe that Shell will start engaging with these communities, even if this reaches the highest court. But we will have to see. Our legal case is very strong, and so I certainly, as of this evening, we are feeling very confident with our clients that even if this reaches the highest court, that we'll be successful. And look, the thing about litigation is it also has many different meanings. Even if at some stage we lose, this has now reached a national platform. People are talking about it, and I don't think anyone will treat these communities in the same way again after this.
All right, we'll continue to track this particular story. Thank you so much for your time. That was Wilmien Wicomb, an attorney from the Legal Resources Centre.